Hello and welcome. Today's program is To Prove, to Please, to Move, Timeless Principles of Effective Advocacy. I'm Peter Afrasiabi. I'm a litigator and partner at 1 LLP in Newport Beach, California, and I'm also an adjunct professor where I teach a clinical legal class at the University of California Irvine School of Law. I've done a lot of programs. You may have seen some of them in our different series on advocacy. And today's program is built around these three pole stars: proving, pleasing, and moving. These three cardinal ideas that motivate us as advocates, whether you're a litigator or whether you're a transactional lawyer, whether you're battling in court or whether you're battling in the boardroom, or maybe you're just sending letters back and forth or engaging in low-level transactions. Whatever you're doing within the legal space, my argument to you today is you need to use these principles of proving, pleasing, and moving. We as lawyers, no matter what we do, we have to engage in the best advocacy possible for our clients, and we do it every day. And so this program is designed to help all of us, not just the lawyers who one may think are the ones using advocacy, but lawyers writing letters who never go to court. You too have clients, and you too have to think about these advocacy principles that you can use to get the best negotiation you could get, or the best transaction you could get, or the best deal you could get. And so this is a refresher course built around these three cardinal principles of advocacy that we're going to unpackage and explore today. So let's get going. Our agenda today and our educational goals are this fundamental advocacy refresher. And many of you may do a lot of advocacy day in, day out. You may think about it, you may write about it, you may read about it a lot. Many of you may just be advocates that don't really stop to think anymore about what are the tools that we are using. Many of you may have only learned about them in law school a little bit, sometimes even not in law school. It may have been an undergrad philosophy class. Because where we're starting is Aristotle. And Aristotle's basic three principles of persuasion that we all know are logos, ethos, and pathos. And we are going to look at those three principles, but we're going to talk about them in the formulation of proving, pleasing, and moving, which are another way of talking about ethos, logos, and pathos. And we're going to use to prove, to please, to move, because that was Cicero's formulation. And Cicero, unlike Aristotle, was a lawyer. He was a trial lawyer. He was an advocate whose job was advancing the cause of his clients against another client in the Roman courts 2,000 years ago. And he is perhaps the most famous advocate from ancient history, who wrote a lot on advocacy and advocacy techniques, and his writings survived through the millennia, and they're still available today to be read. And they can be read, and I've read many of them, and they are fantastic pieces on advocacy. A lot of it is in the ancient world, but a lot of it translates even now, 2,000 years later in the 21st century with our technology, all these millennia away, the other side of the world with a different country, a different republic. Nonetheless, the principles have withstood the test of time, and they are still taught and discussed in the same rubric of ethos, logos, and pathos. And so what we're also going to explore then today are these ideas. It's not just a lesson in history, obviously, about Cicero. That's not the scope of our program. Our program is how these principles work in advocacy in the modern American world, what we all can do to be better advocates for our clients, to be stronger, more viable, more effective advocates. We're going to look specifically at storytelling and credibility, and the importance of these principles that emanate and distill out of the three-legged stool of proving, pleasing, and moving. We're going to look at how we use stories to advance the cause of our clients, not just stories and closing arguments for trial lawyers, but stories for everyone in everything that they are doing for their clients. We're going to look at the audience and how to be an authentic lawyer and advocate, and to understand who the audience is so that you use your persuasive tools appropriately and don't use the wrong tools. And this is why audience matters so much for us to harmonize what we are doing and the message we are delivering. And of course, we're going to look and see at some case law examples of this in practice, of things that have worked or not worked perhaps. And there you see on the right of the slide a cover of a book, To Prove, to Please, to Move, Timeless Principles of Legal Advocacy. It's a book I've written with Chris Arledge, who's a very, very renowned trial lawyer here in Southern California, a fantastic trial lawyer, former law partner of mine. He's at a different law firm now, but he's a fantastic trial lawyer. And so he and I wrote this book focused on trial advocacy techniques to be a better advocate, and appellate advocacy techniques to be a better advocate. And so that's my shameless pitch for the book. This program at some level is a distillation of a lot of what is in the book. The book, however, really gets into the nitty-gritty of effective building of these persuasion techniques in very, very specific areas, such as taking depositions, doing closing arguments, doing appellate oral arguments, and the like. That level of nuts and bolts specificity isn't in today's program, but the book is built around Cicero's ideas and updating them into the modern world for modern American lawyering. So let's get going today. We're going to start with our first leg of this three-legged stool, and that's the one to prove. And there you got a picture of our great orator from history, Cicero. Now, to prove, we unpackage. What does that mean? This is what we are perhaps most familiar with as lawyers, and this is logic. The use of logic to construct and make arguments, to identify strong arguments, to identify weak arguments, to take apart strong arguments and figure out what the weaknesses are, and to rehabilitate and fix weak arguments and make them stronger. And so the root idea behind what it means to prove is the idea that our arguments for our clients are better if they're grounded in principles of logic and sound reasoning. And this idea isn't just sort of pie-in-the-sky hopes and aphorisms. This is sort of a root premise of our advocacy system. And here you have a great quote from a very renowned Third Circuit judge, Judge Aldisert, and this is from his book, Logic for Lawyers, A Guide to Clear Legal Thinking. Excellent book from 1997. And here's a quote. The person who studies logic, law student, lawyer, or judge, and who has become familiar with the principles of logical thinking is more likely to reason correctly than one who has not thought about the general concepts of reasoning. And so this is a very, very important quote and concept that undergirds our system, because our system, at the end of the day, from the perception of judges, the decision makers in our cases, or the perception of your adversary who you're trying to convince to do something, and your adversary has to go back to his client and say, yikes, you've got a problem, you need to do this, right? In order to telegraph those messages on behalf of our clients, we have to use what people commonly accept and understand, and that is logic and sound reasoning that emanates from logic in order to take principles, build syllogisms, apply them, break them down to convince other people. And this is a very important aspect of the concept of to prove, and it's the root one which perhaps we're most familiar with because it's in some sense the easiest one to get our arms around. That was most of what we did in law school after all. But it's also one that one finds, after practicing law for many, many years, that one no longer necessarily thinks anymore in detail about what exactly it is we're doing. We just make arguments, we deconstruct arguments, we attack other people's arguments. And so this is why a refresher is useful to start looking again at some of these root concepts of what are logical arguments, what is logic at its core. So on the next slide, we're going to look at logic and proving, and the idea that logic to prove something, that matters. Now, that is a root premise of this program, that logic matters. If one rejects the idea that logic matters, then one ejects at some level from what we are talking about in this program. But it is built around the idea that at the end of the day, right or wrong, logic matters. And so it's not a normative statement about whether this is a good or bad state of affairs. This is just built around the descriptive reality that we confront as advocates, and that is that logic matters. Like it or not, it matters. And for us to be effective advocates, to discharge our duties to our clients, we have to recognize that logic is a tool we have to employ. Like it or not, it is what it is. So that's the pitch. Deductive and inductive reasoning. We're going to look at them in a little bit of detail, but these are two classic forms of logic that many of us, many of you may have had in an undergrad philosophy or statistics class even. Certainly in law school at some level, perhaps it was spoken about in those terms, but often, even in legal education, it's not spoken about in terms of deductive and inductive reasoning necessarily. It's just learned as a form of a way to argue. And so we're now going to contextualize this categorize it, and put it into a framework that's usable for you. So we're going to work through how to use these deductive and inductive reasoning principles to build tighter arguments and how to not leave yourself exposed. We're also going to look at other aspects of logic and logical reasoning that become important. And these are the outer bounds of logic, where one trips into territory that damages your use of logic and injures you and your client. And that's sort of when one gets involved in personal attacks, red herrings, and straw men. And these are things that happen all the time, obviously, for us as lawyers as we engage with people. And they're thrown back at us in order to attack us, take us apart, perhaps to deflect from the logical arguments that are being made. And we have to recognize how these issues, for lack of a better word, fit into the realm of logic, and how we have to be careful not to fall into the use of them and to be able to identify them and take them apart when they are used improperly. Let's talk now on the next slide about deductive logic. And this is what's often referred to as formal logic. And so deductive logic builds on the idea that we can and do draw specific conclusions from general premises. In other words, this is sort of the idea of syllogisms. We take general premises, and from the general, we distill down to a specific conclusion. And so here's a simple deductive logic syllogism that I've put together for you. And so the major premise is that all licensed lawyers take CLE. Thought that was a fun one since you're all watching this CLE today. So that's our major premise. The minor premise is that Peter is a licensed lawyer. And so the conclusion that one would like to draw from that in using deductive logic, the conclusion would be that Peter has taken continuing legal education programs. And so we go from this major premise, which is a very general premise, to a specific conclusion that we can distill from it through the use of this syllogism. Now, what's important, and it's important to understand deductive logic and these syllogisms because they don't show up in such a neat little package, obviously, in the letter from opposing counsel or the transactional deal document that says, you know, we have to have this term for this reason in this agreement. They don't come in this simple format like I've presented to you here. They're wrapped around in convoluted language and citations to case law and all that. But if we can think in these terms, we can then unpackage and distill what the other side is saying into the major, minor, and conclusion, the syllogism, and then we can figure out if it's right and how to take it apart. And so this is the useful reason why we go back to logic as an advocacy aspect of our toolbox. Now the conclusion, and this is important about deductive reasoning and syllogisms, the conclusion's only true if both of the premises are true. If one of those premises is false, then the syllogism breaks down and your logic is flawed. And whether a premise is false or unclear, perhaps, and misleading, or perhaps it has embedded assumptions, can be critical to whether the conclusion is viable. And so this is why I think it's such a useful exercise, and we look at the syllogism here, and in a few minutes we're going to unpackage this syllogism a little bit more to figure out if there's something about it that's perhaps inaccurate that can be used to take apart depending upon what the argument that's being advanced is from that syllogism. Now here's another important point before we get to the lesson, and that is that a major premise can be a hypothetical too. And so that's in many respects actually one of the most common ones we use, at least in litigation, but certainly in all lawyering, and that, here's an example. A major premise could be that if the plaintiff filed the lawsuit more than a year from injury, then the statute of limitations bars the action. And that's just the basic idea that, you know, there's statute of limitations, it's 1 year from injury. If you don't file within the 1 year, then the statute of limitations bars the action. So that's your major premise. And the major premise here is just a statement of the law, right? It's a statement of the law that you work with if you're, you know, engaged in statute of limitations type legal battles. The minor premise then is that here the plaintiff filed 2 years after injury. And so the legal conclusion that you advance in your motion or your argument to the other side is that the plaintiff is time barred. Now, this of course hinges, again, on the accuracy of the major premise. Is it true that if the plaintiff filed more than 1 year from injury, the statute of limitation bars the action? One has to look at that. Does the law actually say that you only have a 1 year rule, or is maybe your jurisdiction's a 3 year rule? Or does the statute perhaps say something a little bit different, which is, well, there's a discovery rule, and the discovery rule allows you more time, and maybe it's 1 year from the discovery of the injury, and the assumption could be that someone knew about their injury the day it happened, but maybe they didn't. Maybe it was, a latent injury, right? You had an operation and the surgeon left a knife in you and you didn't know about it for 4 months until you started coughing up blood or whatever, right? So this is why it's very important to not get caught into a battle of words back and forth, and to unpackage a syllogism that's being advanced to you so you can figure out how to break it. And the breaks then come by figuring out the accuracy of the major or the minor premise. Now, we talked about the lessons, and this is sort of another aspect of the lessons about the use of syllogisms accurately, either by yourself or by your opponent, and how to unpackage errors in them. And so one of the root lessons that distills from this in terms of teaching logic is that you want to be as narrow as possible with syllogisms. Brevity matters, narrowness matters. Look and see if you can unpackage, can you peel off more layers of your onion and get to the narrowest syllogism possible. And so this is why I want to go back to the first syllogism, because it was intentionally created to give you an example of a syllogism, but also one that could be taken apart perhaps, depending upon what the argument's being advanced. And so let's look at the first syllogism. The first syllogism's major premise was that all licensed lawyers take CLE, and that in order to get to the conclusion that Peter's taken CLE. But if the conclusion one is driving to is that you, the lawyer, you've taken all your CLE, can we really start from the major premise that all licensed lawyers take CLE? Is that actually accurate? Well, they're required to take CLE, but whether they in fact take CLE is different. And so whether one's required to do something and they do it in fact would be a narrowing distinction that could matter depending upon what is the purpose of that syllogism being advanced. And so that's an example where language matters and assumptions matter, and you want to be as narrow as possible for your syllogism. Let's shift now to inductive logic, and this is known in logic circles as informal logic. And inductive logic works the other way, whereas deductive went from general to specific. Now we're going from specific facts or statements to broader general conclusions. And so now we're seeking a conclusion that's not simply limited to its premises, but rather we're seeking a conclusion that is an inference from some very specifics. And so this comes up most often for us as lawyers in any aspect of lawyering in terms of the idea of causation. How we connect a cause with an effect. When X happens, Y follows. There's a slippery floor, someone fell over and got injured, and the injury was caused by the slippery floor, right? We are trying to take a very specific fact, slippery floor, and generalize from that the injury happened from it. And so we want to get a broader general conclusion from a very specific fact. And so this comes up all the times in causation. It also comes up in chronology issues where lawyers can often, both intentionally and unintentionally, conflate chronology and causation. And so assuming a relationship between two events can be very risky. And so this is the danger of using inductive logic without accuracy and caution, because you can very easily slip into a perception that there's causation between two events because of a chronology or a correlation. And that is something that you may slip into and make it, for example, on the plaintiff side, you may make a mistake and think that, oh, I've got a great causation here. And it may turn out that you don't, in which case you don't have a very good case. Or you may be defending a case and the plaintiff may be asserting causation, and you may look at it at first instance and go, oh, yikes, we have a problem. There was a slippery floor. 5 minutes later, there was an injury. It's my fault because, we caused the slippery floor, therefore there's a relationship. But maybe it turns out there is no connection between the two, and unless you unpackage that very carefully, on the other side, you could be wrong. The other way that we do inductive logic, and this is perhaps the most common way, and we learned it as first-year law students, and it's the common law case method, and this is argument by analogy. It's what all the common law courts do, right? You take an existing known observed event, and in the case law process, it's the case of X versus Y from 5 years ago. It's fixed, it's stated, it's a known case. And then you compare it to your case, or you're comparing an observed event to your event. And what you do then is you make this analogy between the two in order to draw a conclusion to be able to say that because that happened in that case, we are like that case, therefore we get a general conclusion that the outcome here should be the same as there. And so we want an outcome from a prior situation to control this situation, and we use inductive logic. And that's what's going on all the time when we're arguing by analogy. And this, of course, is the case law common law method. Now, it's also the way we make figurative arguments when we're before judges or juries, or even perhaps you're making some pitch to your opposing side in a transaction if you're a transactional lawyer and you want them to buy into the idea of an indemnity provision or a choice of law provision that you particularly want. Well, you will be using this type of logic regularly. Either it will be a prior agreement between the parties or built around sort of like general fairness principles or the standard that happens in this industry all the time. And so therefore you need this clause because this is the way the industry operates, right? That type of argument that you're making that we just kind of reflexively go to, now we can understand that in this schemology. It's a form of inductive informal logic that we're using. And so what we do ultimately here, and this is the key takeaway, is if we can organize and put this schemology into what we're doing day in, day out as lawyers, we can better understand the framework of what we're doing so that we can then define where we can push and not push to make things work. And so I think the key point here is that we have to constantly be looking in this area of logic at similarity points and dissimilarity points and the arguments for each. And dissimilarities matter, and this is where I think we see inductive logic breaking down too often. Because I think what happens all too often is that we as advocates, for example, can very easily focus on the similarities and the strengths. That case is similar to my case for these 5 reasons. And then we see 3 reasons it's different and we discount them. And by doing that, we are damaging our use of inductive logic because we're discounting the true similarity between the two because we want to and because we've, as they proverbially say, we've drank the Kool-Aid. And so I think you then can misapprehend the value of the other side's case and you can overstate your case. And so I think if we reframe ourselves and take us back to these first principles of logic, we're able then to sort of better effectively prove and be an advocate. Let's talk real quick about some logical fallacy traps. And these are things that build the band around what we're doing when we're doing logic so that we can make sure we don't fall into them ourselves or we recognize when they're being done and we know how to sort of attack them. The first one is these personal attacks, ad hominems, as we say. And this is when we call our opponent disingenuous or a liar or they're not telling the truth, Your Honor, whatever it may be. And now we are not focusing on our argument, their argument. We're focusing on the character of the person presenting the argument and we're casting aspersions at them as a speaker in order to then try to get the benefit that therefore the argument they're making isn't true. And that, of course, is disliked by courts, as we find all the time. But it also is a logical fallacy trap because their argument may be completely correct. Their inductive logic could be completely correct, even though they may be a speaker who's dishonest in some general sense or they don't have credibility or whatever. It doesn't mean that every word out of the mouth isn't true. And so if you use that too much to try to break down what they're doing, you run the risk of not really focusing on the central issue, which is the application of the logic, and now you're focused on what is an ad hominem personal attack in order to try to get away with something. Or it's the use of red herrings to distract, the idea that we can get away from perhaps deductive reasoning. We don't like the conclusion that's coming, so we use kind of a red herring to try to distract in order to break the logic chain because we don't know what else to do. And so that can come up in other types of syllogisms that get used, like if you let people burn flags, that encourages violence. And so therefore we have to ban people from burning flags because it will lead to violence. That's kind of the use of a red herring to distract from the fundamental issue about is there a right to burn a flag or not vis-a-vis one's constitutional protections. We also have straw men. That's another sort of example of a logical fallacy trap. And this is where we set up false arguments, we demolish those false arguments, and we do that to justify demolishing a real argument. And so you can think of this, and this is very, very subtle. It's often overlooked by the other side when they're responding. And so this can become a tactic that wily advocates may use against you in the hopes that you won't unpackage it. And if they use it against you and you don't respond and unpackage it, it can go over sometimes, and you can end up losing for the wrong reasons because you didn't really break down the straw man. And it becomes a go-to place for advocates when they're nervous about the strength of the ground they're on, so they try to shift the ground by setting up the straw man and then demolishing the straw man and saying, you see, therefore it's the same here. And so this idea of abstracting away from one's circumstances to different terrain where you would win, and then abstract back to your case and say, you see, therefore I win, is an example of a straw man that one has to be very, very careful about. And so one example that you can take here, and this is I just take from my intellectual property practice, and it's just it doesn't come from a particular case law, but it's a simple sort of argument to think about. And so the question is, someone has infringed someone else's work in a copyright case. And so the plaintiff sues, and the defendant says, well, laches. Laches applies, and therefore you can't sue me for copyright infringement. And the plaintiff obviously doesn't like the idea of laches applying, and so the plaintiff then argues that, oh my gosh, if you, judge, allow laches to work this way, you've now created a situation where everyone's works can be stolen at will forever, and that can't be what copyright law envisions, that all these works up on YouTube or something can just be infringed forever. It's no big deal because of laches, right? So you abstract away to something that doesn't make any sense to your audience, you perceive, and then you say, and therefore laches shouldn't apply here. That's an example of just erecting a straw man and then demolishing it. Let's look real quick at this quote as it relates to ad hominems. This is the case of Washington v. Trump, 853 F. 3rd. It's from the Ninth Circuit in 2017. It's Judge Bybee dissenting, but this principle on which he talks is not sort of a principle that he was dissenting on. It's just it happens to be in his dissent, but it's a general principle that's a really good incantation of this idea about ad hominems. And so it's a great way to see how courts perceive this. Ad hominem attacks are not a substitute for effective advocacy. There you have it. That's the cardinal rule. Such personal attacks treat the court as though it were merely a political forum in which bargaining, compromise, and even intimidation are acceptable principles. The courts of law must be more than that, or we are not governed by law at all. So the main sentence here for us, of course, is the first sentence, which is effective advocacy cannot include ad hominem attacks. So there you have it. Stay away from it. Let's also look now at the case of Davidson versus Arnold. And this is a Northern District of California case from 2020. And it's a fantastic case to look at in terms of, again, ad hominems and these personalized attacks and how they're not effective tools or substitutes for advocacy, and they can create real problems. And so here you have a prosecutor and a defense counsel in the court engaged in a back and forth. And this is the prosecutor talking ultimately to the jury in closing argument. Prosecutor says, I was a defense attorney. Now I'm working for the state. I'm doing justice. I'm not getting paid very good money to defend convicted felons. That's a focus on the defendant's counsel, obviously. Your Honor, I'm going to object. The court, it's noted. Keep in mind, first of all, ladies and gentlemen, what the attorneys say is not evidence. It's just their view. You can go back to view the case, though, please. So the defense counsel is upset, as you can see, because the prosecutor is focusing on the character and putting down the character of the defense as if he was getting paid good money to defend convicted felons. That's an ad hominem type attack. The prosecutor, and the court doesn't give what the defense counsel wants. The prosecutor then says, thank you, Your Honor. I'm just saying that in response to the comment that I'm doing defense now and I used to be a prosecutor, there's a contrast. Like, the truth hurts, but the fact is I have no axe to grind in this action. My job is to do justice, not to win, not to confuse just one of you so that my client can walk. I elicited the truth from the witnesses. He confused the witnesses because that's his job. And I know you guys noticed this too. He tried to confuse you right now. Did you hear some of the stuff that he said? Some of the leaps in logic that he drew in trying to argue to his case? He, referring to the defense counsel, is being disingenuous right off the bat. Again, he's a very good attorney and he's doing his job, but he's doing that and it's obvious. So ultimately what the court held here is that, okay, the prosecutor went too far. Those were ad hominem personalized attacks on the defense counsel, impugning the defense counsel, improper use of logic, and actually within the broader confines of the criminal defense world, improper commentary. So now we're going to move to the next component, which is to please. And this idea of pleasing comes from Aristotle's ethos, and this is persuading through the speaker's character. And in modern lingo, we talk about this in terms of authenticity and credibility. And so the advocacy tools on the next slide you see here that we need relate to credibility as a function of honesty in arguments, credibility as a function of being able to telegraph to your audience that you recognize your strengths, but you're also aware of your weaknesses. And that gives you the ability to build credibility so that you have this idea of ethos and you have the right character. And then what we're going to look at is the way that we can utilize compromise as a tool to actually augment and generate credibility for ourselves. Here you have, just I put as an aside, a quote from Winston Churchill. And this is sort of an example of how he used ethos, as you see here in the quote, to generate credibility for himself because of his, his experience in the assembly and his ancestral lineage in it, and that he used to generate the necessary ethos and credibility as a speaker for him. So that's just an example. You can find loads of examples. That's just sort of a good one, I thought. Let's talk about this in a little more detail now, about this idea of how we get credibility in terms of pleasing and how this works for lawyering, because this infects all aspects of lawyering. And it doesn't matter from letters to discovery, to depositions, to motions, to mediations, to arbitrations. In all of them, we may be doing different aspects of lawyering. The same way you go to Home Depot and you see a given brand of tools has the same color combination, but there's 50 different tools for doing 50 different things in your house, but they all have the same color. That brand, you can think of credibility as the same thing. Everything we do as a lawyer, the brand color is credibility. We have to have that same color brand credibility, that handle, that black and white or, red and green or whatever the color is of the brand. We have to have that, and that's credibility. And here you have a quote from Cicero, which I think is as true today as it was 2,000 years ago. All my efforts are always concerned with this goal, for I will say it again and again, to do some good by my speaking if I can, and if not, at least to do no harm. And so this is what's really important for us as speakers. Our goal as advocates has to be to do as much good as we can for our clients, but certainly not to harm them. And so this line between helping but being careful not to harm helps mediate when we can lose credibility and go too far and say something that actually damages our case, at which point we're not focused on that cardinal goal of Cicero. This comes up in overselling or overstating, when, tossing out words like, disingenuous, outrageous, frivolous. I mean, those types of words are trigger words we find for courts that ultimately can harm your credibility. And they're often uttered and used and driven by this desire to act. And so the advocate is focused on, trying to do something to help their client, right? What Cicero said, I want to do good by my speaking. And that's the motivation. But what often happens then is that our motivation gets the better of us and we go too far and say something that ends up overwhelming and damaging our ability to maintain credibility. And so I think if we keep focused on this idea, this Cicero idea of do no harm, if you keep that mantra in your mind as you are engaged in your written and oral advocacy, you will build your credibility as a speaker. And this cuts across its age, experience. It can be the first-year lawyer or the seasoned lawyer who's been practicing for 40 years. It cuts across time and generations. I think do no harm is the mantra that lets us maintain the best version of credibility. Now, one aspect of credibility that we've spoken about is the idea of compromise. And this is a critical tool and critical lesson, I believe, for us as modern advocates to recognize. And that is a very important principle, that compromise is not weakness. And that can be staggering to many of the lawyer. Many of the lawyer believes that to compromise on anything is a sign of weakness. And so what that creates is a culture of never compromising at all, holding on to everything against all costs. And what it ultimately does is damage the credibility of the advocate, damage the credibility of the speaker. And this emanates from a fear of making concessions, a fear of conceding points in the belief that it shows weakness or that something's wrong. And I would argue, and I would submit, that the better model is to recognize that if one has overstated a position or one has to concede something, instead of hiding from it and holding on to it against all odds, embrace it and use that concession as an opportunity to, in effect, make a gift in order to try to get something back. And so this is how I think we can gain credibility if we make concessions, because it shows our ethos, the honesty of the speaker. And I think part of the problem this stems from is the idea that better advocacy is more arguments. And that's something that at root was drilled into us as first-year law students, obviously, right? We had tort exams with crazy hypotheticals, and the student that got the highest grade came up with every cause of action under the sun, no matter how ridiculous it was. And the ones who didn't see the craziest causes of action weren't rewarded for being creative enough. And so I think that idea emanates the practice of law then, and it ends up with lawyers making all sorts of arguments that just don't have traction and holding on to them because that's just what they've been trained to do. And so I think if we can see concessions as gifts, we can see that making a bad argument is a blow to credibility. And so if one abandons it, one has the ability to make a concession, and an unused good concession is a lost gift. And this I talk a lot about to my students when I teach my clinical classes. I talk a lot about it in education programs I do at law firms on advocacy and concessions. And this stems in part from a lot of social psychological literature in terms of the value of concessions in enhancing one's credibility in terms of building demeanor, honesty, credibility. So let's look at modern American advocacy and lawyering and this idea of credibility in pressing legal arguments. And so here we're going to look at a quote from U.S. Supreme Court Justice Robert Jackson. This is a quote from the 1950s. And he said, "Legal contentions, like the currency, depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed an error. But receptiveness declines as the number of assigned errors increases. Multiplicity hints at a lack of confidence. Multiplying assignments of error will dilute and weaken a good case and will not save a bad one." That's a critical advocacy quote on credibility for us to unpackage, look at, and recognize. And here he talks about it in the context of appellate advocacy, but it's true in all contexts for advocates. And that is, the more you press on weak arguments, the more the listener becomes less receptive to the belief that anything you're saying is strong. And the reason for that is credibility. This is a way of unpackaging this concept of credibility. And so the more you assert things that are weaker and weaker, the more you damage whatever good ground you have to be on. So if you're a transactional lawyer and you have 9 arguments for why this indemnity clause should be this way, but 4 of the 9 arguments are they're just kind of weak and cheesy, but you don't let go of them. What you do by pushing all of them is you don't overwhelm by shock and awe force and get the other side to say, oh my gosh, they have 9 arguments, fine, I give up. What you do is telegraph, okay, this person's kind of nuts. They're making arguments that are so weak, that don't have a good basis, that I'm not even going to take seriously anything they're saying. And so what you've diluted is your good argument. On the next slide, you can see, for those of you who are science or engineering or math inclined, I've converted Justice Jackson's quote into an XY-axis chart, and we can call it the currency of credibility chart. And I think it's a good name to give it because credibility is our currency as advocates when we are on this leg of our 3-legged advocacy stool. We need credibility, and that's the currency by which we operate, right, as advocates. And if you want more currency with your audience, you want to be high on that x-axis. There it's receptivity to error, but it could be just receptivity to your argument or buying into your argument, whatever you want it to be. If you want to be high, you need to be making fewer arguments. And the more times you either assign error if it's an appeal, or you're telling the jury that the defendant did 47 things wrong as opposed to the 2 things wrong he really did, and you're just tilting at windmills on the rest, or it's my example I gave you for the transactional lawyer on pressing too many reasons why they should get a clause they want, you damage your credibility. And so you want to be at the high credibility zone, which I think requires one to be responsive and reflective to the idea that we get credibility by not pressing weak arguments, letting go of weak arguments, and knowing the ground that we can stand on, which itself telegraphs that you're an able, capable advocate in the realm of credibility. One basic tool, and this is sort of in some sense the best tool for us as lawyers in terms of how to get credibility, and this is why it's called Credibility 101, and that is we can establish at a baseline necessary credibility simply by knowing the law and knowing our facts. And this is the most foundational step, and if we trip over this step, we damage our credibility out of the gate. And so the best thing that we can always do in all of our cases to possess credibility with whoever we're engaging with whether it's a litigation case, a negotiation, whoever you're acting as an advocate for and against, is utilize logic properly, establish your credibility, and you do this by being 100% accurate about your facts and knowing the law. If you're wrong on the basic law that governs your situation and you don't understand it, you are going to destroy your credibility with whoever you're speaking to out of the gate. And if you misstate, either intentionally or accidentally, you just don't know your facts properly, you're going to destroy your credibility too. The audience expects you to, at a minimum, know your facts and know the law perfectly. There can't be room for error there. And it's a big burden to carry as an advocate, but reflexively or reciprocally, it's easy to manage and learn, and that's one thing that we can actually, if we make the sweat equity, we cannot mess up there. And so that's the best way to get a baseline level of credibility and not trip the wire. Next, we're going to look at authenticity as a tool to developing ethos, this credibility. And one way to pose the question is, how can we be our most authentic lawyer self? And this is a difficult process, and it takes time to unpackage, and it takes thought. But I think what it requires is these two basic concepts to develop more credibility as an advocate. And that one is to know oneself, to do a difficult audit of your strengths and weaknesses, do it yourself. Ask your law partners to do it. And it's a brutal experience, but it's very valuable to do, discussions, arguments, whatnot, with those you're close to and trust, and ask for honest feedback. And if you do that kind of a sort of a self-audit of strengths and weaknesses, you are able to then figure out whether the way you're presenting or what you're pushing and arguing for is legitimate material to push. The other aspect is to constantly recognize that one has to speak honestly and transparently as an advocate here, as opposed to trying to deceive. And I think this line is a line that it's all too easy for lawyers to cross over and to go from honest transparency to legalese gray lawyer talk, which is really language designed to deceive. And one way to think about it is just simply the difference between someone who engages in hard sales versus someone who is a trusted guide working through a problem. And if you can maintain that line and that distinction between the two, you can preserve your credibility. So here we're going to now look at People versus Donaldson. It's reported at 93 Calap 4th, page 916, and the quote you have here comes from pages 927 to 928. This is a 2001 case. And this case articulates the advocate witness rule. And this is a very important rule to unpackage in terms of the difference between a lawyer being a fact witness and vouching for facts and being an advocate. And so this is a rule that bridles us in our advocacy for fairness principles. But what it also does is illustrate and exemplify the critical nature of what it is to be an effective advocate. And so the rule that limits what we can do is grounded not just in sort of ideas of fairness to the system and propriety. Of course, it is grounded in those things. But it's also grounded in the very idea that effective advocacy requires us as lawyers to understand these lines. And so let's look at this quote. If a lawyer is both counsel and witness, he becomes more easily impeachable for interest and thus may be a less effective witness. Conversely, the opposing counsel may be handicapped in challenging the credibility of the lawyer when the lawyer also appears as an advocate in the case. An advocate who becomes a witness is in the unseemly and ineffective position of arguing his own credibility. The roles of an advocate and of a witness are inconsistent. The function of an advocate is to advance or argue the cause of another, while that of a witness is to state facts objectively. So this principle, it's a very, very important principle of generally applicable jurisprudence for litigators and advocates, is also one that applies to even transactional lawyers. In terms of your advocacy, in terms of trying to vouch for facts as opposed to being an advocate of what the story is, right? And so I think it's important for us to unpackage this a little bit because it's not just saying that, oh my gosh, if you're a trial lawyer and you're also a witness, this puts you in this sort of a position where it's ineffective to argue your own credibility, and so your credibility may be damaged because you're a fact witness and maybe you're shown to be a liar, and then you're getting up as an advocate and now no one's going to believe you. That's all true. But the flip side is what's particularly true for us, and that is you don't want to be seen as anything other than an advocate. You don't want to be in the dirt yourself of vouching for what is a fact or what is not a fact, because that gives the other side the ability to injure and damage your credibility. And so it's important, I think, for us as lawyers and for advocates and to engage in proper advocacy to constantly keep in mind that we don't want to sacrifice our credibility as an advocate by shifting our argument or narrative into one of sort of we go from here to here and now we're sort of kind of telling the jury that these are the facts. And we can fall into that logical trap because we're standing here as a lawyer. We think, maybe you think with this jury you have great credibility, they love you, or with this audience they really like you, they trust you, your credibility, you have good ethos, you've been doing a great job. And so now you want to shift and kind of slide your argument into vouching for the fact that the light was red when the car went through it, or whatever the fact is, because you think you're a better vehicle to telegraph that than the witness who testified who maybe wasn't as good, right? That damages your credibility ultimately. And so we have this rule in terms of keeping these lines as a rule for fairness in the system and propriety in terms of fact-finding, but also it's a reflection fundamentally of credibility and the role of advocacy for us as lawyers. And so I think if we unpackage the rule and understand it in that way, this lets us be careful in terms of how we maintain our credibility, and we don't over-abuse our credibility to try to get something that we're not entitled to get. So now let's move to the final, the third leg of our stool here with Cicero, and that is to move. And the idea of pathos from Aristotle, or to move from Cicero, is this idea originally of framing the perspective of the audience by appealing to the right emotions. And so it's the idea that we want to appeal to the right emotions to get the audience to look at our advocacy efforts, the witnesses, our story, our narrative, our letter writing campaign. We want them perceiving this narrative through the right prism, the right frame of mind, and that's appealing to the right emotion. And so if you can adjust your audience's prism, maybe it's one in a given case, it demands just abject kind of sympathy, sadness, the victim. In another one, it may be, the audience may be more receptive to sort of a different prism. You shift here now, it's David versus Goliath. In another one, it may just be, fair custom and industry and commercial trade. Whatever the prism is, you want the audience to see things through the right prism. And it's the right use of pathos then to get them to employ the right level of emotion for your situation so that you can be the most effective advocate. And so this on the next slide you see here is about touching and swaying the audience. And so here is where we talk about how do you engender this pathos? How do you sway that audience and get them to use the right emotion? And this is where the advocacy tool of storytelling is so important. This is where word choice and arrangement is very important. And the use of schemes and tropes, for example, are as tools of an advocate in developing pathos. It also looks at voice inflection and changes in the use of voice, intonation, up and down, an effective pause, and the like. And then emotional knowledge. This fundamentally also requires us as an advocate, in order to move people, we have to have the right emotional knowledge about our audience. And so this requires knowing our audience. And so these are sort of the tools in the toolbox of the advocate who's building on the ability to move people to your advocacy and your outcome. So let's look on the next slide here, and we're going to start with this idea of storytelling at work and how storytelling and credibility intertwine. And so you see there a picture of rock star Bono from U2 and Senator Jesse Helms. And this is a fantastic sort of story we can look at to unpackage this idea of storytelling. And so here, it's a double use of storytelling going on right now. The two of them are obviously a most unlikely pair. I mean, we've got Bono, a European rock star, and his liberal progressive agenda, sunglasses on at all times, indoors and out, leather jacket, and the like. And we have Senator Jesse Helms, a very conservative senator from the South with a long history of advancing conservative agenda and causes in America. And the crisis that brought the two of them together, where you have the picture there, is the AIDS crisis. And Bono wanted American taxpayer dollars to go to worldwide AIDS relief. And Senator Helms was the one senator that was holding this up. And, President Bush, this is during President Bush's years, he was in favor of the bill, but Senator Helms was opposed to it and didn't want the money to go. And he had a long-standing history of not believing that America should spend money in all these places that weren't our business, and he was opposed to it. And so it was rooted in his own political philosophical belief system. And Bono has a different political philosophical belief system. And so Bono shows up at Senator Helms' office, and Bono arrives with his Bible. And as the story goes, he opens his Bible, and this is his personal Bible, and he connects with Senator Helms over their shared common ground of their Christian faith. And Bono shares with Senator Helms the parable of Jesus and the lepers, and talks to Senator Helms about how Jesus, 2,000 years ago, taught us today, as the teachings go, that the lepers should not be treated as outcasts. They should be loved just as anyone else. And that's a core tenet of Christianity. And as Bono then argued, the AIDS epidemic today is like leprosy in Jesus' time. This is an epidemic that's afflicting people, that's unfair. It's not their fault, and that they deserve help the same way people with leprosy in the time of Jesus deserved help. And he used this story, this very powerful story, to shift the framework of Senator Helms. He shifted Helms's framework into his own framework and was then able to appeal to Senator Helms through this prism. And it worked. Not only did Senator Helms shift his position on this, his deeply held political philosophical conviction about the role of government and the American taxpayer abroad, he shifted. And not only did he shift, he wrote an op-ed piece saying, basically, I was wrong. We need to support this bill. The bill passed, the money went, AIDS relief happened from the American government. And so this is a sort of perfect example of, I think, the effective use of storytelling and pathos to appeal to the audience. That was the right prism in that situation for Bono. And we as lawyers have to constantly be looking for the right storytelling for us. And so this brings us to the next slide in terms of what do we even mean when we talk about storytelling? I mean, we tell stories all the time. But what's important, I think, for lawyers and advocates to recognize is storytelling is not just a closing argument for a trial lawyer, which is obviously actually a very rare event in the law, right? I mean, most civil litigators go to trial rarely because 99% of cases settle. And even criminal lawyers who go to trial more, most of the cases get resolved. So closing arguments are a sort of very rare experience for even the litigator. But storytelling isn't just a closing argument. It's all aspects of a case, and then it's all aspects of even the non-litigators' transactional efforts. It is how we frame our client's business dealings, position, negotiation, case, whatever it may be. It's how we frame it. And so we use storytelling to frame it. And this is where metaphors and analogies become really very, very powerful, I think, in terms of building a case and a story. But it often starts with the idea of once upon a time. And that phrase, once upon a time, that starts, fairy tales we read when we were children and books, is a phrase that has universal use. In English, we say once upon a time. Japanese language uses mukashi, which conveys a very similar concept, once upon a time, going back in time. And then, of course, even in modern mythology, like the Star Wars films, how do they all start? A long time ago in a galaxy far, far away. It's another incantation of this idea of once upon a time. Those words themselves hook us into this pathos. We're being moved by understanding this is, these stories that we then tell. So we use the idea of stories. It's sort of endemic to human nature, human beings across all cultures, which is why we as advocates can't just abandon it and suddenly act like a robot. We need to be telling stories too. And I think our primary job then is to be constantly telling our clients' transactional or litigation story and to be using transformative stories in a way to help advance our cause. And this is done constantly to explain and connect arbitrary rules to fact patterns and outcomes, to transform, for example, the harshness or the arbitrariness of a rule to a necessary or outcome that we may want. And so stories function as this bridging tool or function between what are otherwise often sterile or very boring rules or perhaps even seemingly unfair rules. And we bridge those to an outcome we want by storytelling. And so we are doing that all the time, and I think the most important lesson I leave here is to recognize that this isn't just for trial lawyers in closing or for Bono speaking to Senator Helms. We must do this at all times. The other aspect of moving people is word choice and arrangement, and this is sort of the idea of schemes and tropes as rhetorical devices. And so just as a quick recap, schemes are when we change the word variance order, we repeat certain phrases in a rhythm to emphasize, think, I have a dream, and the way Martin Luther King Jr. used that repeatedly in the speech, that repetitive phrase becomes rhythmically moving and it emphasizes something. We use pauses in speech and variance in sentence structures and length, and that's the written word or even the spoken word. And it can be very, very powerful to have sentences that are then followed by 2 or 3 word sentences that are very short. That even breaking up one's writing in that way is using a scheme that's valuable to move people. Tropes, of course, are metaphors that we use to compare and draw drama between things. And so it's metaphors, or it's using similes, as-like type comparisons, rhetorical questions, ironic understatements, exaggerations of some things, even in closing arguments, if it's for effect, like if you're exaggerating perhaps the way the other side talked about how much they were injured and it's so over the top, you can take advantage of that and you use that, then that's an example of a trope that you use to move people. Word choice is important, and here you see the picture of some sheet music, and I think word choice is something that isn't focused on enough by lawyers in their advocacy efforts, and it's something that can be focused on, it can be learned, and it can be done. And so it's an example of a great advocacy tool that we can all improve upon and learn ourselves to do more. And so this is genuinely a please, prove, and move poll star. This is sort of a ribbon that goes around all 3 legs of the stool. And so I think spending time appreciating words and the word style in writing is genuinely invaluable to improving our own writing and our oral presentations of all kinds. And I think energy and focus on that lets us do that to find what are the right words to move people in the right way. And one perfect example of that is the difference between, and we can zero in on a trial lawyer making an argument in court, and I use that because that's the easiest metaphor for me to use as a litigator, where one is going to talk to the jury in their closing argument about their client's damages. And one can signal to that to the jury in different ways. One could just tell the jury, okay, now let's talk about damages. And that's one way to do it. That's a way that's often done. And you're telling the jury, we're going to talk about damages. Now you want the jury to start shifting and get ready that you're going to start talking about the injury, the money, and how much is owed and all that, right? But another way to do it is just to think about the word choice. It's technically true to say, let's turn to damages. I mean, the law divides cases into liability and damages, and we talk to judges about damages. We get damages awards and damages verdicts, right? But another way is to stop and unpackage the words you're using and to appreciate words, to think about it. And isn't it more powerful for whatever your story is as the plaintiff if in your closing you say, let's now, ladies and gentlemen, assess the unfortunate pain that befell my client. I mean, something like that. It's the same thing as damages. We're not going to talk about money and injury, but it's a better way to do it because you help move people into the right prism of what you're talking about. The great news here is all of this can be learned. Practice, practice, practice is the answer. I come back to Winston Churchill, who I've come back to in many of these programs. That was a lesson he gave, he did. He didn't become the great speaker he was just off the cuff. It was all about practice. On the next slide here, beware. We've got to keep careful at all times as advocates. We got to think constantly and be careful about what it is we're doing as we appeal to emotion, and we have to be careful that we don't overstate our case. And so there are limits here. We have to be careful that we are not engaged in what is just a naked appeal to the listener's emotion. If it's just a naked appeal to emotion, that ultimately trips multiple aspects of these advocacy tools we've talked about. You trip the logos, the logic. It ends up tripping the logic if you are engaged in naked appeals to emotion. It can often damage you, the speakers, your credibility, your ethos, right? That gets blown out of the water. And what it also often does is it demonstrates some lack of understanding about as you as a speaker about what it is you're trying to achieve. And so that damages your credibility in respect to your audience. And so I think it's very, very important to not let words confuse us. When we talk about the right emotional prism, appealing to the right emotion of our audience, it's all too often confused with just the idea of appealing to emotion. And that is where people go wrong. You can't just appeal to emotion. That's why I used the Bono Senator Helms parable. He didn't just appeal to emotion. He didn't just come in and say, my God, it's horrendous. Like, millions of people are dying. It's terrible. It's sick. It's outrageous. How can you let people die? I mean, that naked appeal to emotion wasn't what he did. It was very, very different. And that's why I think we have to be very careful as advocates, because it's all too often the case that the advocacy tools we talk about with respect to emotion and using the right emotion get confused with just a naked appeal to emotion. And Aristotle, it's great to go back to the ancients, because Aristotle said, I mean, it's even true today, thousands of years later, right? Aristotle said that using outright appeals to emotion is the equivalent of measuring distance using a crooked ruler. You can't get any better than that. And so that's my beware pitfall for you. Let's take a look then at State versus McGuire. And this is a case from Connecticut, reported at 310 Connecticut 535, 78A 3rd. It's from 2013. And so here we have a great example of just naked appeals to emotion and the problem with them. And here's a quote from the case. It's axiomatic that a prosecutor may not advance an argument that is intended solely to appeal to the juror's emotions and to evoke sympathy for the victim or outrage at the defendant. An appeal to emotions, passions, or prejudices improperly diverts the jury's attention away from the facts and makes it more difficult for it to decide the case on the evidence in the record. When the prosecutor appeals to emotions, he invites the jury to decide the case not according to a rational appraisal of the evidence, but on the basis of powerful and irrelevant factors that are likely to skew that appraisal. An improper appeal to the juror's emotions can take the form of a personal attack on the defendant's character or a plea for sympathy for the victim or her family. So here, it's a really important point, right? I mean, this is the idea that it's not just advocacy teachers, people who practice and teach and lecture on advocacy like me, telling you that naked appeals to emotion are wrong. This is a court explaining that not only are they wrong, they can actually be illegal and unlawful in certain circumstances, like this criminal example. But this case yet is another reflection of why they're wrong. They actually damage the ability of the lawyer as an advocate to do what an advocate is supposed to do, and they start substituting us as advocates for other actors, we can say. And so this is an example of where the prosecutor overstepped some bounds, and sort of the court had to explain why these naked appeals to sympathy for victims or outrage at a given person aren't a substitute for proper advocacy of lining up facts and law, which can be done. One can appeal to the right emotion using pathos, as we talked about. You can bridge the law and the facts. You don't have to do it with these naked appeals to emotion. And of course, that gets to my final slide for you here today, which is the audience matters. As you saw in all of this, especially on pathos, you have to get the right prism. Is it here? Is it here? Is it here? Is it here? What is the exact right prism? It's a function of your audience. For Bono, it was Senator Helms. For you, it may be a jury. For someone else, it may be an adversary in a negotiation. For someone else, it may be a very friendly deal that's being done where it's kumbaya, everyone's happy, they're getting together, it's a great transaction, but they're still an adversary. But every audience that you deal with is different, and it requires a different lens. And so we have to be aware of whether our audience is a trial judge, and this requires then unpackaging the audience in detail. If it's a trial judge, what does that mean? It means it's a judge who's got hundreds of cases, who's hyper busy. You may be showing up to talk to the judge, and the judge has 17 other cases that day. You have to be aware of all that so you can understand what tools in your arsenal you use, given that audience's bandwidth and time pressures and what's going on. Your audience could be appellate judges, which is a different audience. It's 3 judges, less cases, 3 minds, all ready to engage in a very, very different way. You see that in all the appellate programs I've done. Those people are a different audience. It requires you to give a different pitch yet again. Jury, different yet again. An opposing lawyer on the other side, different yet again. An imposing in-house counsel, different yet again. Audience matters is the point for you to harmonize your message properly and use pathos properly. So in conclusion, You see here, our principles were to prove, to please, to move. If you as an advocate can prove, please, and move, you'll be the best advocate you can. And so I hope today's program, you take these tools from the program, you unpackage them, and you start using them consciously in all of your advocacy efforts. It'll help you get credibility. We've talked about how to get it, how to hold on to it, how to not lose it. Understand storytelling and really focus in on the use of stories in all aspects of lawyering. They don't have to be over the top, but stories are needed at all times. And then we looked at case law examples where we saw these advocacy tools being lost and damaged by misuse by advocates. Thank you very much. Again, I'm Peter Afrasiabi. Email me anytime with questions. I love hearing from you about these programs. Thank you.